Further hearing of the appeal, Royal Mail Group Limited against Jhuti.
Yes, Mr. Gore.
Lordship, my lady, your lordships, I said I wouldn't be long. I don't think I will. I have three things to make submissions on. The first is our analysis of the narrow exception that Mr. Jones elucidated during the course of yesterday. And that needs a bit of attention, we say, and a bit of detail. And we'll come to that. The second is, as Lord Hodge asked, what are the consequences if that narrow exception is to be accepted and to be applied? And the third is something we have to say in relation to remission and the very narrow point, as my Lord Carnworth identified yesterday. Well, can't you just rely on the Employment Appeal Tribunal's outcome or decision? Before I do that, we have agreed between the parties that insofar as looking at codes of practices or other guidance, there isn't any that deals with a case like this. So I said yesterday that I didn't think there was. We've agreed between the parties there isn't. The point we were making yesterday is that whilst there isn't a specific set of guidance to deal with a trialist procedure or a performance procedure, the reason why I took you to the trialist procedure yesterday was to show, in fact, what Royal Mail did in relation to this particular claim and following the procedure. So all the good practice that we identified yesterday, they applied, we say. In other words, we let you know what the problem is. We give you an opportunity to address it. If that doesn't work, we then put you through a formal process which involves a manager at a higher level to your current manager, and you're afforded rights of representation and so on and so forth, and then there's an outcome and then there's an appeal. So whilst there isn't any specific statutory guidance, the good practice was followed, we say, in this case. So can I go, therefore, to my first point in relation to Milena Friend's reformulation of what he says the liability test ought to be under attribution. He said yesterday, just before or shortly before he finished his submissions, he refined it further to saying that really what is involved here, and for you to find for the claimant or the appellant, is that there needs to be a manipulator who is overwhelmingly motivated by a protected disclosure, point one, and the action of that manipulator determines the outcome. Now, the first point we make about that is to take you to MS 58, which is in fact the written case that Mr. Jones and Mr. Jackson have advanced, inviting you to what they said at the time to find for the exception as they advanced it. And that we're not dealing with the simplest case of MS 58A, because that would be, the simple case would be if that was Mr. Widmer who took the decision, there would be no issue about that. That if the tribunal found that he was motivated by the protected disclosures, that would be a case within 103A. We're not dealing with that. We're dealing with the corrupted process case or the setup case. Now, in respect of the corrupted process case, the formulation as set out in the written case was that there's a culmination of a process in which the manipulator is formally involved on behalf of the employer, and the manipulator's actions are the effective cause of the ultimate decision to dismiss, and the manipulator is principally motivated by the making of the disclosure. Now, we say Mr. Jones's reformulated case is a departure from that. It's a complete departure from that, because the actions of the manipulator no longer have to be the effective cause. The actions actually have to determine the outcome, and the motivation of the manipulator, which has to be on the printed case, the principal motivation, is completely changed by the new term or the new rubric he introduces, which is the overwhelming motivation. So that's a radical departure on his feet, as it were, and orally, to the written case which you were invited to consider for the purposes of this appeal. That doesn't necessarily mean that you're not going to consider it, but that's hardly a sure-footed start to what the appellant is inviting you to do for the purposes of this narrow exception. And likewise, under just finishing it off, the submission that my learned friend made under the corrupted processes case was that the formal involvement of the manipulator can involve any worker, including a co-worker. So, in other words, extremely wide and extremely broad if that is understood on the written case, and in fact that is maintained on the oral case. My learned friend's written submission in relation to the setup case, which is at CMS 58, was that this again has to be the culmination of a process in which the manipulator has had input, and the input is the effective cause of the ultimate decision to dismiss, and the manipulation is motivated by the making of the protected disclosure. And again, that alters in that the actions are no longer the same as with the corrupted process case. The actions are no longer the effective cause, but in fact have to determine the outcome, and the motivation is no longer the principal motivation, it has to be the overwhelming motivation. But where the abandonment has come in my learned friend's case is that the setup case doesn't apply to ordinary workers, it's someone on the same level, the co-worker point. What we say with that is that is not a coherent formulation of a liability test. That is a wide-ranging attempt in order to fit the facts of this case into an exception under Section 103A. And we say that's an impermissible exercise in principle. Can I just then analyse what, in fact, is the meaning of determining the outcome or the overwhelming motivation? We say, what does determine the outcome mean? Is that the exclusive and only cause? My learned friend seems to put a hook on paragraph 346 of the Employment Tribunal's decision, where they say it was an inevitable outcome. Well, that's not the same, we say, as determining the outcome. It has an influence and has a substantial influence, but it doesn't have the same meaning as determining the outcome.
Inevitable surely means the inevitable outcome surely means a direct causal link.
Yes, but how is that measured? We say what is the threshold test for that? Is it for instance that it's more than 50% of the influence? So take this example: if Mr. Widmer had mixed motives, so Mr. Widmer thought in part she was a poor performer, but in large part thought that that the claimant needs to be retaliated against because she made protected disclosures. On this analysis on determining the outcome, what's the effect of those mixed motives? Does it have to be, what is the threshold of my learned friend's argument for the purpose of the exception of saying that his actions
on your hypothesis, the principal reason would remain the protected disclosure?
That's dealing with motivation. On my case, the reason is what Ms. Vickers had in her mind. And,
we know that, yes. But you're exploring the alternative.
Yes. The alternative scenario, yes. But we say that what then is the under the determining the outcome? What then is the effect of the decision of Ms. Vickers? Because the outcome, in fact, is what she decides. She's not, as we looked at yesterday, she isn't, as it were, the puppet of of Mr. Widmer. She's the person who receives information both from Mr. Widmer and Mr. Reed. So how can it be said that what Mr. Widmer has done has determined the outcome, other than providing information? Those are just examples, we say, of why my learned friend's formulation just doesn't really get off the ground, let alone it breaks down on analysis. My Lord Wilson asked Mr. Jones yesterday about, well, what is the meaning of the culmination of a process in exchange? And my learned friend's response was, so in other words, under the corrupted processes case, it starts with the decision as the culmination of a process. Under the corrupted processes case, Lord Wilson asked Mr. Jones what he meant by that, and he said a decision that is a culmination of a process that cannot be divorced from the process but encompasses anyone who has any involvement in that process. So it is as wide and broad as one can possibly imagine, which is what he has to argue for the purposes of a corrupted process case, because he says that anyone with a material influence counts. So we say determining the outcome is problematic, if not insoluble, and motivation is even more problematic. What's the overwhelming motivation? What does that mean? It's not a legal test. It's something that the appellants have just put before you yesterday afternoon orally in submissions. What does that involve in terms of threshold? Is there a percentage assessment in relation to Mr. Widmer? Again, go back to the example I used a little earlier, which is to say he has mixed motives. What is the position then in relation to overwhelming motivation? Does that mean that those mixed motives, the innocent motives, count, or do they not count? What does overwhelming motivation mean in those circumstances? And we say again that makes it unworkable as a starting proposition. And we also say this, that the framework that my learned friend posits is in fact not a correct framework, respectfully to him, because he posits it on the basis of saying that there's a corruptive process case or a setup case. Now, that might be an argument, he says, in order to get him home. But of course, this case and the ramifications of this case aren't just about getting his case home. It's about the implications and the consequences if his case gets home. And what we say is that the case that he developed in relation to setup and corruptive process can't sit with an awful lot of other cases which don't involve any such matters, but would involve, on his analysis, a much wider, broader analysis of what the reason is, not attributed to the employer. The example we give is what Lord Hodge, yesterday, my Lord Hodge asked of my learned friend in relation to what of the case of somebody who's not performing, but that person is not performing because the underlying reason is bullying. Now, there was no suggestion that would involve protected disclosure or any prescribed reason, but on my learned friend's framework case, it falls outside of that, but there's no reason why it should fall outside of it. It should entirely be inside it. So what does that mean? Well, what we say that means very, very succinctly is that it just becomes, as it were, open season in the employment tribunal. So we say for those reasons, briefly dealing with the oral case that was advanced and is reformulated, which my Lord Conworth put to me yesterday in terms of the narrow exception, we say, properly analysed, it doesn't work. It throws up too many imponderables, too many uncertainties next to what the plain reading and the plain wording of Section 103.
I hope Lady Hale won't mind my saying this. I think there'll be grave problems about people at the back hearing you properly, Mr. Galton.
My Lord, I'll get between the microphones a bit more.
No, the microphones don't do any help at all.
Oh, right.
The
Well, I'll
first
project my
job
voice.
of any barrister is to make himself heard, with or without amplification.
Yes.
The microphones are for transmission all the way around the world to the people who are listening to you. But the important thing is that we can all hear you. It's also important that the people in the court hear you. I'm most grateful to Lord Wilson. I sometimes feel some inhibition in mentioning myself, knowing that my hearing is no longer as good as once it was, but nevertheless.
Thank you.
Well, I'm also grateful to Lord Wilson.
Thank you.
Indication to project, and I will.
Could I just project a practical point as a consequence? If an employer has been put into the situation which the Royal Mail was put into here, and it discovers that there has been some manipulation, what are its obligations to the employee? Does it have to have a fresh inquiry? And is there a further detriment if it doesn't? How does it all operate? I mean, this is assuming, of course, that it discovers within a reasonable period of time. It may not do so until some years later in the course of the employment.
Well, that's a different proposition because that's what a tribunal declares to be the facts, not
Sure.
what the employer knows at the time.
But if he does discover?
But if an employer, take the extreme example, if during the inquiry of Miss Vickers, she wasn't happy with the explanation given by Mr. Widmer as to the claimant's complaints about the TMIs, it was perfectly open to her in those circumstances to find performance isn't engaged in these circumstances. We think there has been an element of victimisation, and then there's a whole new process that opens up.
Yes, that wasn't my hypothesis. Suppose that she makes a decision that the appellant should be dismissed, but sometime a little later, perhaps during the appeal process, all these facts start coming out. Does the employer have an obligation to reconsider the decision to dismiss?
Well, if it's through an appeal process, yes, because the person who conducts the appeal has the right to overturn the original decision.
And then after that?
Then after that, it's slightly less clear, because what then happens normally is that the parties are set against each other in litigation.
Yes.
And that's when it leads then to a tribunal and the findings of fact by a tribunal. But insofar as it still retains an internal life, then if Miss Madden, who was the appeal officer in this case, if Miss Madden formed the view that there was something to this, and of course we know that Miss Madden looked into this in great detail. She had both the grievance and the performance issue put together and investigated matters, including interviewing certain key persons, including Mr. Widmer and Mr. Reed. If she came to that, then there are a number of options for the employer. One is that the appeal is allowed.
And it's reinstatement and all the rest.
The dismissal disappears, so the claimant goes back to her job, and no doubt there would then be a process against Mr. Widmer, if that was her view.
But it might have been a demotion and not a dismissal, and sometime later, months after the appeal process has been concluded, all this comes to light.
Yes.
And does the employer then have an obligation to the employee to revisit the decision?
I'm not sure that they have an obligation if they've exhausted the procedures, but if she remains employed,
yes,
then there will be, the claimant has an opportunity in which to raise another grievance, and the claimant can then say, by the way, I remain employed, I've discovered this, here's my grievance. And then the employer is then, under the ACAS code, obliged to investigate and come to a decision. So I suspect the dividing line is when the employment relationship exists, next to when the employment relationship doesn't exist. Lady.
Yes, understand. Thank you.
And can I finish off on my first point, if I may, on whether this in fact is a narrow exception at all? And we say it isn't. How this case is brought is based on a prescribed reason under Section 103A, the claimant having made a protected disclosure. Prescribed reason dismissals are quite numerous in the detail. We set this out at MS 107 under our Schedule A, which for these purposes I'm only looking at 98B1 down to 105.1. Now that isn't the full estate of proscribed reasons, but those are the ones that appear, and we've given you the statutory references to them. So we say, far from this being a narrow exception, because it's a prescribed reason case that would apply to a public interest disclosure matter, there is no reason at all why the claimant could not, or other claimants in different circumstances, use the narrow exception in other proscribed reason cases. And that's, we say, another good reason to reject the claimant's argument.
But standing back, surely the cases in which the decision maker doesn't get to the bottom of the reason for the dismissal must be very, very rare. And in this case, there was a perfect storm, wasn't there? Because Miss Vickers was only asked to review. There was no active investigatory role given to her or to anybody else. And of course, Miss Jhuti was ill and didn't turn up at the meeting that Miss Vickers had arranged. So for various reasons, she simply didn't get to the bottom of what this was all about. And so we are surely dealing with a hugely rare situation.
Yes, and that would be my point as to ultimately why, on those very hard facts, you shouldn't make bad law, would be my ultimate submission. But these are exceptional facts. They are. I accept that. I don't respectfully accept that what Miss Vickers didn't have an interrogative function to it, because I took you through that yesterday in relation to what her role was and what her decision was. that she had information provided to her, but she assessed that information herself independently. But to answer your question, my lord, yes, this is to a degree a perfect storm case, and that's the point that I've already made as to why perfect storm should not alter the settled law of employment. That ultimately will be our point in relation to Ossipov, which I'll take you to very briefly. But my lord, on the basis of the submissions yesterday by my learned friend, it's not just confined on his case to proscribed reason cases. On his case, in exchange with you yesterday, he accepted that this could be in an ordinary unfair dismissal case. Yes. So once you, as it were, take the lid off, it's off. And we say for those reasons, analysing how the appellant case is reformulated and re-put, there's every reason to reject it on the grounds of incoherence and unworkability and the effects that it would have on employment law. Now, I want to go then to my second point, which is consequences, and make a series of points as to why we say this would introduce a series of unwelcome and negative consequences into a stable area of law, namely unfair dismissal. And the first point I make is the point that I've just made in relation to my learned friend's reformulation point, which your lordship, my Lord Wilson asked yesterday, which was that really this is an attempt or a consequence of an attempt to disrupt the Foley settled principles of substitution. And again, I go back to Lord Hodges' example given to my learned friend. I'm not sure my learned friend actually worked through his answer, but this isn't just confined to prescribed reason cases on my learned friend's own admission. And on our framework analysis, it's a much broader framework that you're looking at. And so, by a side wind, through the application of a company law doctrine of attribution, you have the edifice, the settled edifice of employment law, disturbed, if not completely displaced, we say. And it might be, therefore, that what my learned friend's argument ought to have been is that Foley's wrong, and that's a good reason why you should do it. But you've not had that argument in this case. And as my Lady Hale said in Riley and Sandwell, and as indeed Lord Wilson said in Riley and Sandwell, that appears to be a system which has gone along and had broad acceptance, and nobody has sought to change it. But on our analysis of the appellant's case, they are seeking to change it through this rather left field argument in respect of attribution. And that would be removing the Foley doctrine by way of a side wind. And indeed, and I needn't take the court to it, that's one of the compelling reasons in the majority decision in Orr, but why Moore-Bick and Aikens LJ reject the employee's argument in Orr. And I give the references. It's paragraph 64 for Lord Justice Moore-Bick, MS 1139, and paragraph 87 for Lord Justice Aikens at MS 1145. And we adopt that, as we do in our written case, and say that Orr majority is absolutely correct. And indeed, just how that would begin to change and I'll come on to make a very brief submission as to what how the job of the tribunal would change if my learned friend is right. What we say is that on my learned friend's corrupted processes case, which could involve anyone with an input, anyone with an influence, that really would be the widest inquiry one could imagine, because it would simply be a claim that would say, I think X, Y, and Z have an input. The tribunal would be obliged to inquire subjectively into what that input was, rather than on the Foley orthodoxy, which very simply is that it's not for the job of the tribunal to inquire as if it was the employer. It's an objective analysis that it undertakes. So we say, first consequence is the removal of the Foley doctrine through a side wind. That cannot be right. The second, we say, is that this has practical and profound consequences for employers, We set this out in our case at MS 97, paragraph 51.6. But can I just tease out some points which I say are of significance? Is that we've looked at the good practice and settled practice of internal hearings and what ACAS encourages and what good conduct should actually be. On my learner friend's case, that could be bypassed because it's not what the employer thinks. Ultimately, on his case, it's what the tribunal finds to be the reason. And so what then is the status of an employer holding and trying to attempt to hold a fair hearing internally if in fact all this is going to do potentially is end up in an employment tribunal? It undermines fundamentally the settled practice of resolving matters internally, which could go a number of ways, including Lady Arden has suggested. Well, it could be that in fact there isn't a dismissal. It could be in fact that there's a step short of it. And very, very basically, we say, well, this is our quasi-adversarial process approach, which we traced through under good practice yesterday. Basically, what an employer is confronted with is a problem and a decision. And the employer makes a decision based on receiving evidence and receiving representations. And that's all underlined by the 1999 Act, Section 10, which we looked at. And so really what that is about is a very simple question is, for an employer is, what do you believe? And very often it becomes, who do you believe? On the learner friends analysis, that doesn't matter, because if there are influences of others whom you're ignorant of, you are, in those circumstances, capable of having your decision reviewed and set aside by way of the tribunal's findings based on the law of attribution, as he argues it. And likewise, the dismissing officer, and this is an important point which my learner friend, we suggest, hasn't really grappled with. The tribunal, and this goes in part to the remission, the tribunal in this case made the finding that Miss Vickers dismissed. Miss Vickers had a reason in her mind which was performance and is genuine, and had nothing in her mind in relation to protected disclosures. The learner friend's case is, well, you ignore that on his argument of attribution. But how do you ignore that, we say, when in fact the simple inquiry under Section 98 and Section 103A requires you to look at what Miss Vickers has done. So on my learner friend's argument, what he wants you to do is create this legal fiction whereby you take out and you ignore what Miss Vickers did. And he did accept, my Lord Wilson, to your question yesterday, that there aren't two decision makers, there is only one decision maker. So we say, well, what's the status of Miss Vickers' decision in these circumstances? And more importantly, what's the status of the Employment Tribunal's decision? On his case, which we say hasn't been satisfactorily explained, that is just ignored, when in fact we say that is simply wrong. And another point in relation to why the effect on an employer and what it might have a negative impact on an employer is that the whole idea of having rules and having procedures, both in terms of performance and conduct and so on, is that not only does an employer set out what it wants in order for its business to be run efficiently, but an employee knows where they stand for those purposes. And what, if my learner friend is right, if the appellant's case is right, and what an employer does by seeking to step into a sphere in which there could be a dismissal, is the employer then opens itself up to a whole potential swathe of litigation based on the motivations not of the decision maker, but on others, on my learner friend's very basic and simple case. And we say that would have an inhibiting effect on employers properly running businesses and having a proper and efficient workforce. It would be the fear of the tribunal shadow, which would loom very, very large in those circumstances. And there are two specific legal points that we make which have a significant impact on employers defending cases in employment tribunals. Two specific impacts. The first is the impact in relation to a loss of a statutory defence. We looked at this briefly and in passing yesterday, and that's MS 552. We looked at this in the context of the changes that were made in 2013. This is Section 47B of the Employment Rights Act. whereby the amendments were made following the case of Fessett, which decided that a worker-on-worker detriment does not come within section 47B1, because that's not the act of the employer. And what Parliament then did was introduce liability in respect of the worker's conduct being actionable. So that's 47B1A, or the agent of the worker, his or her action becoming actionable. That then is, under the process of vicarious liability, that then is imputed to the employer under 1B, where a worker is subject to detriment by anything done as mentioned in subsection 1A. That thing is treated also as done by the worker's employer. So there's your vicarious liability imputation provision.
But it is vicarious liability, isn't it?
It is vicarious liability, my lady, yes. That's why I say imputed rather than attributed. And then at 1D, an employer has a defence in respect of anything alleged to have been done as mentioned in 1A. It's a defence for the employer to show that the employer took all reasonable steps to prevent the worker from doing that thing or from doing anything of that description. So, inbuilt into the careful parliamentary legislative scheme, I beg your pardon, is a checks and balances analysis in which an employer isn't held strictly liable. An employer, unless it's under 47(1)(b), and this is my point, an employer is liable under vicarious liability principles for the acts of its workers, subject to an all reasonable steps defence. Now, on my learned friend's analysis, given that he says that the acts of Mr. Widmer is the act of the employer, under 47, that must come under 47B1. And indeed, that was how he opened his case yesterday. So in other words, an employer who has taken all reasonable steps to ensure that their staff don't engage in this sort of conduct is stripped of that defence on the learned friend's analysis, because this must be and always will be the act of the employer. So we say that, as a consequence, cannot possibly have been within the contemplation of Parliament. In other words, providing a defence only not to have a defence. And that's a significant reason, we say, why learned friend's interpretation should be rejected. And a second point, which is not quite as emphatic as that, but nevertheless is illuminating, is the section 92 right. Can I just take your ladyship's and your lordships to that which we looked at yesterday briefly at MS 583 under the Employment Rights Act, Part 9, Section 92, which is the right to seek a written statement of reasons for dismissal, where a person has qualifying status, they make a request, and page 585, MS 585, section 93 is where I want to go to, is the remedies or the complaints part of this provision. A complaint may be presented by an employee on the ground that there's been a failure to provide a response. We're not looking at that. B, the particulars of reasons given in purported compliance with that section are inadequate or untrue. Now, just pausing there, on my learned friend's case, the employee will always fail on an attribution case because what they've said to be the reason, expressed to be the reason, isn't in fact the true reason. Or if it's anywhere close to the true reason, it's an inadequate reason. So my learned friend's argument would have the effect, as it were, of making a claimant in such circumstances always succeed under Section 93. That would be a remarkable outcome, I say. And a third point is the consequences for employment tribunal hearings. Very briefly, we know how the Foley Doctrine works so as to keep those cases relatively manageable, and I mean this respectfully, in contrast to discrimination cases, which we know can last days, weeks, months, and so on. If my learned friend's argument are right, then the focus goes into the employment tribunal, and this only will lead, we say, to an employment tribunal's burden being significantly increased, hearings lengthened, and the like. And I took, my Lady Lordship, to the point yesterday in relation to Kuzul. In employment tribunal, it's for the employer in certain qualifying circumstances, if the employee has the right to claim of dismissal in the ordinary sense, that on Kuzul analysis comes down to where there's a clash of argument. The employer says, I dismiss for this reason. That's rejected by a tribunal. The employee says, no, you dismiss me for this reason. The onus then moves on to the employer to disprove the reason. So what you've got, therefore, on the basis of Kuzul, we say, is, as it were, a further obligation on an employer to prove the negative based on the learned friends, we say, wide and expansive case, which is culmination, who's had the influence, what is the influence, and so on and so forth. And my final point on consequences is really a point that my Lady Arden raised with my learned friend right at the end of the submissions yesterday, which is, well, the rule of attribution that we have looked at in the cases that we've looked at, Meridian Global and Bilter, is all about a company law concept based on the proposition that a company needs human agency in order to operate. And of course, that's beyond doubt. And the process of attribution in the three ways identified, I needn't go back to it. That's how, for the purposes of a company, attribution may apply depending on the context and purpose. But here, what is the position in relation to a sole trader employer, or an unincorporated association employer? What is the status then of, is there a concept of attribution? We've not seen anything from the appellant in relation to that. What that could do potentially is throw up, as it were, a distinction based on who the employer is. In other words, if an employer is a company or a corporation, yes, my learned friend's narrow exception, if you accept it, might apply. But if you're not a corporation or a company, what then is the whole applicability of the doctrine of attribution? So you could have attribution applying for the purposes of a company, but not for the purposes of a sole trader or an unincorporated association. That's before we even begin to get into the highly complex area of partnership or limited liability corporations, or limited liability partnerships. And so what we say is that if this point is allowed in any way, you potentially could have a situation in which you have an employer being defined for the purpose of attribution in different ways. In other words, you've got a right to run attribution if you're employed by a company. You may not if you don't. And so, finishing off my submissions on part 2, I did say yesterday I would come to OSIPOF, and I am coming to OSIPOF very, very briefly, if I may. All this analysis, or all the analysis on behalf of the appellants, is put on the basis that this is a terrible situation, the hard facts, as my Lord Wilson said earlier. This is an awful situation, a perfect storm. The claimant is going to be deprived of a remedy. Please do something in relation to 103A and apply the rule of attribution. And we say that might have some attraction if the claimant had no remedy at all in these circumstances. But we say the claimant does, because that's where we say that the case of OSIPOF assists the claimant in principle, and it's no more than in principle in this case. So OSIPOF is in volume 4, tab 41, MS 1423, which is the case where the facts are 1423 are very simple, in the sense that the CEO was Mr. OSIPOF. He was dismissed, the tribunal found, for having made protected disclosures. And the question was then, well, who was responsible for the losses which flow from that. The claim was put on detriment claims and on a 103A claim. Mr. Osipov succeeded on a 103A claim, but the company was insolvent, or turned out to be insolvent. But Mr. Osipov also brought claims against individual officers of the company, alleging that they were responsible for the dismissal and therefore should be responsible for the economic consequences of the dismissal. And that's issue M, which is the dismissal case. If I can just give you the references to that, how the case was put before the Employment Tribunal is at MS 1428, at paragraph 35, there identifies the case based on dismissal. That was Mr. Timmis and Mr. Sage, who were the directors, so he brought a claim against them. And issue detriment M was that they were responsible for any instructions or recommendations given by the respondents so identified, which culminated in the claimant's dismissal. And that's further set out at paragraph 43, MS 1429, where Lord Justice Underhill talks about the upshot of all this. Although they weren't held to be liable for the claimant's unfair dismissal, they were held liable for the losses he suffered in consequence of the dismissal. The argument which was being raised, which is a technical argument, which was that under 47B2 of the Employment Rights Act, you can't complain of a detriment that is a dismissal under Part 10. And all that this case decides is that that just simply bars a dismissal, claiming a detriment against an employer as a detriment for dismissal. It doesn't bar claiming a claim for dismissal against an individual worker. Again, nobody in this case doubts the correctness of Osipov in principle. So that's the first part of Osipov, dealing with it very quickly. But that's not this case, because the claimant's case wasn't that Mr. Widmer brought about the dismissal as Mr. Sage and Mr. Timmis was alleged to do under M. The claimant's case in this case, subject to how it will be argued further on, is those detriments that we identified yesterday in relation to E and F, which was the plan.
The fault may be mine, but in paragraph 80 in MS 139, Lord Justice Underhill declares that the claimant is not precluded by the way in which her claim has been put in the Employment Tribunal from advancing a claim for losses occasioned by her dismissal.
Yes, I'm not. I only touch on that. I'm not arguing it. I'm not going behind.
No, but we have a ruling by the Court of Appeal that, notwithstanding what was said, and you referred us to it earlier in the Employment Tribunal's judgment at MS 157, that the two grounds of pleading that were upheld were paragraphs 2E and F.
Yes.
The Court of Appeal is saying, notwithstanding the pleadings, they're allowing the claimant to make an Osipov claim.
Well, it's open to her in principle. That's as far as the Court of Appeal go, which is to say it's not barred.
On the pleading, but doesn't your limitation point depend on the pleading?
It does, but what I'm coming to, if I may, Lord Hodge, now, is to say how that case in principle is permissible under Osipov, and we don't quibble with that in principle at all. Whether that actually, whatever the Court of Appeal declared, it's for the tribunal to decide on principles of recoverability and so on and so forth. But all I'm saying here is that there is a remedy in principle for the claimant, and that's the second part of Osipov, which I was about to take you to, which is paragraph paragraph 79, which is at MS 1434.
Sorry, could you repeat that number?
Paragraph 1434, my lady.
Thank you.
Which is compensation for dismissal consequent on detriment. So in other words, it's not saying that the dismissal was an act of detriment, but saying that steps identified as detriments give rise to the economic consequences of dismissal. And in part, this touches on this case, which is what my Lord Hodge was referring to insofar as what the Court of Appeal's order is concerned. And again, the argument was being put by counsel for the employer, and indeed Mr. Justice Mitting found himself, that that case is somehow barred by 47b2, and that's rejected in paragraphs 81 and 82. And specifically, as it were, the defining principle is in paragraph 84, where Lord Justice Underhill says, it follows that I would hold that a 47b2 places no barrier to recovery of compensation for losses flowing from a dismissal which is itself...
You're inaudible.
I'm sorry, my lady. I would hold that 47b2 places no barrier to recovery of compensation for losses flowing from a dismissal which was itself caused by a prior act of whistleblowing detriment. For the avoidance of doubt, such compensation would be subject to the usual rules about remoteness and discounting for the contingencies, including the contingency that the employment might have terminated in any event. So, as a matter of principle, we say there's no hardship that is worked to the appellant in this case, so as to begin to justify taking the radical steps that the learned friend invites you to take. And very briefly in relation to 3 remission, if I may, before I sit down. We say if you get to that point, there is still the fundamental issue of what is the status of the dismissing officer, her reason, as found as a fact by the employment tribunal. So how is it that that is gotten over for the purposes of making a declaration that the claimant's dismissal was contrary to section 103A? We say it's impossible in those circumstances to make any such finding.
Well, how does this fall under the rubric of remission? We will have dealt with that, won't we? Before getting to remission.
But you will have done, so remission then in those circumstances may not arise.
No.
But if you are able to, as it were, demolish it, if you're able to deal with it, then I accept that there's no argument in principle. If that is how the legislation is going to be interpreted, that is the outcome in favour of the claimant, in favour of the appellant.
What was the order made by the EAT in this case?
The order made by the EAT was that there be a finding of section 103A dismissal. And that's, you have the...
So we can simply, if we're against you, we simply affirm that.
Yes, that's a MS 141. And unless there's anything more, those are my submissions.
Thank you.
I think not. Thank you very much indeed, Mr. Gorton. Mr. Mitchell? Yes, Mr. Jones.
Lord, what I'm about to say, I think should not take too long, but divides into 2 categories. The first part of my learned friend's submission set out what one might call his positive case. Then this morning we've heard what he has to say about my case, and I'm going to split what I have to say to you into those 2 sections. Starting with what he had to say yesterday, can I just ask you to spend a moment thinking about the broad thrust of his argument, which is essentially this. And we go some way down the path with him. He says, given that dismissal usually follows a decision to dismiss, that we say probably inevitably follows a decision to dismiss, the law anticipates that the employer will make a decision, and thus that there will be a decision maker. And we can't contest any of that. That is all plain common sense. But what happens next in his argument is he moves from that assertion to saying, well, it therefore follows that attribution should never go wider than the specific decision maker. And the problem with that argument, we say, ought to be immediately apparent. It assumes the conclusion. So the issue in this case is, should you ever look more widely than the decision maker? Should an attribution rule attribute to the employer, as part of its reason for termination, something which was not in the head of the decision maker specifically? And we say, for the reasons we set out yesterday, and which I must return to in a few moments, the answer is yes. The second point he makes is, and he put it very charitably, he said that he thought on our side of the room we may have inadvertently misled you as to whether or not Mr. Widmer was going to be responsible, you may recall, for the decision on whether or not probation was going to be confirmed. Can I just show you why we said what we said? You'll need to look in the core bundle, please, at MS 210. And here we're deep in the tribunal's findings of fact. Can I invite you first, please, to look at paragraph 196, which is the one beginning later on the 7th of March 2014. You will see about halfway down through that paragraph, there's a line which begins, wanted to discuss the complaint. The next sentence says, however, she was offering her money to leave. It was at this point that Ms. Rock also told the claimant that if she remained at the respondent, Mr. Widmer would still be responsible for her probation going forward. And if one looks at 198 on the same page, the claimant emailed Ms. Rock explaining that on the basis that Mr. Widmer would still be responsible for passing her probation, she wished to take the matter forward formally. So whatever the position in theory, by reference to policy, so far as the tribunal's findings of fact were concerned, they were finding that the Royal Mail's position had been, in interaction with the claimant, that it would be Mr. Widmer who would make the decision going forward. So our position is we, I hope, have not misled this court at all, whether wittingly or unwittingly. What we've done is reflect the actual findings of fact. That point was developed in a further way, which is what was said is if you look at Ms. Vickers' decision letter, you'll see she makes reference both to Mr. Widmer and Mr. Reed. And in relation to that, we say two things very quickly. Firstly, when one looks at the detail of it, what one sees is she's assessing Mr. Reed's view of progress against the performance improvement plan. But you'll recall that being subjected to a performance improvement plan was itself one of the detriments that the tribunal found had been imposed as a result of the protected disclosure. But putting that aside for the broader point, our case was and remains that within the scope of the rule of attribution, to use the language in Orr and Milton Keynes, may be anyone to whom a Section 98 function has been deputed. It's possible, of course, that had this case worked out differently on the facts in the tribunal, that the tribunal might have said, well, that is Mr. Widmer, and it's Mr. Reed, and it's Miss Vickers. But in fact, the difficulty that my learned friend faces is paragraph 346, in which the tribunal has concluded that the decision was inevitable because of Mr. Widmer's input. And the submission yesterday amounts, as it were, as an attempt to say, turn your gaze away from 346, let me persuade you that there are more people involved, and they may have had a determinative influence on the outcome of the decision, but that runs instantly into what we say is the barrier of paragraph 346 over which my learned friend cannot climb. So the last of the points that he took yesterday that I need to address very briefly is what one might call the Orham Parliament case. If Parliament has not further legislated to deal with the consequences of Orr, it must follow that they're taken to be happy with it. We say yes, but to this point, firstly, if you assume that Parliament knows about Orr, of course you must assume that it also knows about Bilter and Meridian, and that it understands that out there are rules as to how one attributes to a company, or I'm going to say later in other circumstances too, in the case of individuals. the motives or actions of others. So they will know about vicarious liability principles, they will know about primary attribution principles, they will know about special attribution principles, and it's those that we're seeking to apply here. But also, to develop a theme further, our position has been and remains that these are very, very unusual circumstances, which, as I understand it, Mr. Gordon accepts. And a presumption that the Parliament will intervene to legislate to deal with rare edge cases, it seems to me, is an unsafe one. And then finally, we say, of course, in relation to corrupted process specifically, that it's consistent with or, as Lord Justice Underhill decided below. And where we differ from him is we think also a line manager case ought to be in the unusual circumstances where what you're looking at is an attempt to procure a dismissal rather than a good faith attempt to get to the bottom of an issue. So that takes me to what's been said this morning.
Could I just ask you, why should Parliament have wanted to impose liability, even if this was a rare edge case? Because it means that the employer becomes responsible for dismissal on the basis of facts of which he was not aware.
Well, we say it doesn't, because what ultimately happens as a result of the application of this principle is the employer becomes responsible for a dismissal that it procured. So to say how could the, and in fact I must come to this in a moment when I deal with one of the points which has been made this morning, to say, well, how could the employer have been aware of this, is to assume the answer to the proper approach to attribution.
It all depends on what you mean by the employer.
Exactly. So can I turn to the question as to whether or not there's been radical reformulation of our case, which I certainly hadn't intended to do, but I accept that if everyone uses more than one word for something, you're at risk of that being suggested. Let me try and be clear about this, as I'd hoped I'd been yesterday afternoon. There is a clear threshold test. And the clear threshold test is the one embedded in section 103A, which is that you're looking for the reason or the principal reason. And Mr. Gorton, as far as I can tell, is not suggesting that that is a threshold test which is likely to surpass the understanding of an employment tribunal. It's one they apply day in, day out in unfair dismissal cases. So what you're really asking when you're looking at the motivation of the manipulator and the extent of the influence of the manipulator upon the decision maker is looking at those two stages. Can we say at the end of the analysis that the employer's reason or principal reason was the manipulator's reason or principal reason? So if, where the tribunal finds in relation to Mr. Widmer that his overriding reason was the public interest disclosure, all that's telling us, for the material purposes of our formulation, is that they are inevitably concluding that it is either his reason or at the very least his principal reason for his own actions. And when they find that the outcome was inevitable, that's the strongest possible finding in relation to causation. So they must be therefore concluding that the reason for the dismissal is because it is inevitable and arises from his motivated actions, to have his motivation as the reason or principal reason. So there isn't a difficulty with threshold. It's the familiar one in the Act. We're not seeking to rewrite it or supplant it with any other kind of language. We're just saying that when you look at that factual situation, that's the yardstick you have in mind.
But the courts have construed the word reason as meaning facts known to the employer.
Facts or beliefs, indeed, which takes us back to the whole question in this case, which is who's the employer? And
well, it's still got to be known.
yes, but it is known, in this case to Mr. Widmer, why he's doing what he's doing. The tribunal's entirely clear that he understands that he is motivated by public interest disclosure. And in his role that he is performing in this process, he's acting on behalf of the employer. So one other way of looking at it is this. This is not a case in which Mr. Widmer was in some sense just a witness. It's not like they walked out into the office and said, could anyone who's seen Ms. Jhuti working pass an opinion, please, on her performance so that we can take it into account? It's literally his job to assess her performance and to subject her to performance improvement measures if necessary. And in an ordinary case, we say, on the facts the tribunal has found, to determine whether or not her probation is successful. So if one asks the question, generally, and also specifically within this process, whose job was it to formulate the view on performance, assess it, and create the records? It's his. And in doing that, he's acting as the employer. That's why it falls within 47B.
So if the Royal Mail has an employment handbook, I'm just asking instead of information, I'm not trying to indicate anything, that says that all employees should be aware, make themselves familiar with the protected disclosures legislation, and will not, if they're in a managerial position, not cause any detriment. I'm not using language that would be used in the handbook, to any other employee. And so the employer has put that on the line for all employers and made it indeed probably a disciplinary offence to do so.
Yes.
What relevance would that have under 103A?
Well, I need to take you there in two stages. So the logically prior question is what relevance does it have for the purposes of section 47B? So if an employer says, don't subject anyone to a detriment, but someone who is acting qua the employer does subject someone to a detriment, there is no employer's defence. So this is one of the points that you heard made this morning, and it's right. So
It has no defence, the employer has a defence.
the employer doesn't have an employer's reasonable steps defence. So let me walk through Mr. Widmer as an example.
But if the employment handbook has told Mr. Widmer that that's not reasonable steps.
Well, it might be, but it doesn't matter for the purposes of section 47B1 because there is no defence to section 47B1.
Right.
So if Mr. Widmer, acting as line manager and therefore acting as employer, subjects Ms. Jhuti to a detriment, I don't think it's contested, that will fall within section 47B1. And in those circumstances, the Royal Mail could have written as many handbooks as it liked. It could daily have reminded people that they ought not subject people to a detriment. That won't get them off the hook because his actions are the employer's actions. And we say, given that his actions are the employer's actions under section 47B, one, it would be pretty surprising if they weren't the employer's actions under section 103A, which is part of the same scheme. So I don't think there's any doubt that when he acts in the way in which he does, he is representing the employer. His actions are treated as the employer's actions. When one comes to section 103A, the question is, when I'm defining employer there, am I going to go wider than just the decision maker, or am I going to take into account what Mr. Widmer does in circumstances that the Act already makes clear are the employer's actions and the employer's knowledge? So you recall at the very start of my submissions, the very first stage of the factual journey, simplified factual journey, was that when Ms. Jhuti makes the protected disclosures to him, to Mr. Widmer, she's treated as making them to the employer. So there's no question that the employer is unaware of the disclosures. She makes them. Because Mr. Widmer is the employer, there's no question that the employer is aware of Mr. Widmer's actions because he is the employer for the purposes of section 47B. There's no question that the employer is unaware of why he's doing it because he's the employer for the purposes of section 47B.
But under section 47(1)(d), in proceedings against the employer in respect of anything alleged to have been done as mentioned in subsections 1A,
Yes.
then there is this defence.
In a vicarious liability case.
No, in respect of anything done as mentioned in subsection 1A.
But 1A is vicarious liability.
Yes, but you only have to bring yourself within that, i.e. the act of a co-worker.
Yes. So if I go back to the factual distinction identified earlier between, say, a colleague who was asked an opinion, but whose job it is not to form a view on the employer's behalf in relation to performance, and Mr. Widmer. Mr. Widmer would fall within 47B1. The colleague would fall within 47B1A.
Yes.
And in those circumstances, if the Royal Mail attends at tribunal and says, please look at our handbook, where we say don't subject people to detriment, they might have a defence in relation to the colleague because they're only going to be liable for their actions on a vicarious liability basis under section 1A, subsection 1A, but they don't have a defence in relation to Mr. Widmer, precisely because his actions and motivations are attributed directly to the employer and are the employer's actions and motivations under 47B1.
Right?
So in section 103A, the second stage, we say, well, who is the employer there? Are we going to take account of actions that we know to be the employer's actions, Mr. Widmer's actions, knowledge we know to be the employer's knowledge, Mr. Widmer's knowledge, motivation we know to be the employer's motivation, public interest disclosure in relation to his actions, or are we instead going to say, well, we'll just draw a line around the decision maker for this purpose? We say you don't do that in circumstances where he is, as it were, the determinative or effective cause of the decision itself. So if Miss Vickers had conducted some wide-ranging and independent inquiry, and the tribunal had found that her decision had been tainted by Mr. Widmer's actions, that it had been a factor which had been taken into account, but it could not be said to have been, as it were, the or the principal reason for her reaching her decision, then our claim would have to fail, because we need that double threshold, first in relation to Mr. Widmer's, why Mr. Widmer is doing what he's doing, but also in terms of the degree of causal determination of the final outcome, which is why it's only, at the risk of irritating everyone through repetition, it's only in very rare sets of circumstances that you're going to have a case in which we would succeed. It's going to be extremely rare that you're going to have a case as strong as this one is, where the tribunal has determined overriding reason for Mr. Widmer's actions and inevitable outcome decision-making stage.
Well, while it may be rare that cases will succeed, is there not a danger that if there are, as the respondents say in Schedule A to their written case, many prescribed reasons, that people may try to assert that the true reason of a line manager was one of the prescribed reasons and that he has in some way tainted the investigative process?
Exactly right, they will, which, what I'm very grateful, takes me to the next 2 points made by Mr. Gorton. So can I start with the narrowness point? He says, we're not suggesting it only applies in public interest disclosure cases, and he's right. We don't suggest that. We do suggest that in general, if a manipulator has an overriding, or they have in their own mind a reason or principal reason for action, and they succeed in manipulating the outcome of a decision to the extent to which it is effectively determinative of it, then that will apply generally. But it's still narrow in the sense that it only applies in those extraordinary narrow sets of factual circumstances. So it's not the range of cases in which it might arise, it's the range of circumstances in which it might arise, which is narrow. But Lord, you say, well, isn't it likely that people are going to be arguing this more often? And this is one of the consequences of our arguments which was raised. And it was raised in two different ways by Mr. Gorton. The first was, he says, there's a problem about width of inquiry. So he says, well, it's going to be said that anyone with input into the decision is someone in relation to whom an allegation can be made by a claimant that they have in effect a determinative outcome. Well, the first point is that's not right, for the reasons that I was explaining a moment ago to Milady Arden. It's not anyone who has input. It's not a colleague who is asked to express a view. It's not every witness in a misconduct case. It's people to whom, to use the OR formulation, the employer has deputed some function of their own, which is a critical element of that process. So it's people who are involved on the process side of things rather than people who merely have some input. So it isn't as broad as my friend has suggested. But the difficulty with, even if I took his argument at its highest, the difficulty with his argument that the tribunal is going to be faced with people arguing that other people had input and thereby manipulated the decision is that they can already do that on his case. So there is nothing stopping them doing what happened in Ozipov, which is that you turn up with a Section 103A claim, which Ozipov they won, but also run a detriment claim. So even in circumstances where the tribunal was satisfied that an allegation had been made that there should be attribution that should have resulted in a Section 103A outcome. Not satisfied of that, they can still go on and conclude that it was sufficient to amount to a detriment, most likely under 47B1A, because you'd be dealing with a vicarious liability case. So it's not like the tribunal is going to be spared having to consider these issues, even on my learned friend's case. It's just that they're going to have to consider them under two headings rather than under one heading, but they're going to be considering the same issue and the same evidence.
But 47B applies only to protected disclosures.
Yes.
There are all the other prescribed reasons. And if you have a line manager who is assessing the performance of an employee, he or she may be influenced by one of the prescribed grounds. And were it not open to the employment tribunal an assessment of those matters where these matters wouldn't arise absent a provision equivalent to 47B?
Well, my lord, I entirely take the point, and I don't have, as it were, a conclusive answer to the point, save to say that tribunals are expected to take the decisions they need to take to produce justice arising out of the potential legal liabilities. And if we ever found ourselves in a position where we were saying, yes, but some people might bring claims that won't succeed, and therefore we shouldn't extend the protection, whatever law and principle suggests, then that would be a very comprehensive putting of the cart before the horse.
Of course, surely it's very rare for these points to turn up first before the tribunal. The tragedy of this case was that your client was ill, she didn't attend the meeting, and the emails that she sent, through no fault of hers, yes, were difficult to understand.
Yes.
In the normal case, surely, the employee will turn up at the hearing and say, the real reason why they want to get rid of me, yes, is such and such, so the decision maker deals with it.
Yes. So to come back, I'm very grateful that takes me to the Foley point, which I ought to deal with. Nothing that we are saying requires you to overrule Foley, much as I might love to invite you to overrule Foley. Nothing we are saying requires that in this case. And the reason, because, as my learned friend put it very eloquently, Foley is a substitution issue. So there are various points at which a tribunal might be tempted to substitute its view. And let's posit that one of those points is the point at which one is considering the reason for termination. We agree that the effect of Foley would be that it's not open to a tribunal to substitute what it thinks the reason for termination should be. But what it is obliged to do, has always been obliged to do, and will still only be obliged to do as a consequence of our argument, is to decide what the employer's reason actually is. And that will turn, as again, at the risk of over-repetition, on who the employer is to be treated to be for this purpose, the attribution principle. So much as I would love to see Foley falter and fall, it doesn't have to as a consequence of anything we have said. And Lord, to just develop that into your point, it's right that the question as to what the true reason for dismissal is frequently challenged in proceedings, of course. It also happens, of course, in any case in which there's a dismissal where it's being alleged that discrimination had played a part in termination. And that the real reason that someone has been dismissed is not because they were redundant or because of their performance, but it's hostility to their race or their sex or other protected characteristic. So the tribunal is well used to having to say, what's the reason here, where are the motivations, who has participated, what has influenced them. And to take your second point, our own case, this case, is a good example of exactly what you've said, which is that when this case reached tribunal, it has, as they did in Osipov, both a Section 103A claim and detriment claims. So all of those matters are already patent on the face of the proceedings. And in a normal case, you would expect that to happen. So at risk of contradicting myself, I'm already saying it's an exceptional case. So I'm saying in a normal exceptional case, if such a thing exists, you would expect it to look like this. So it's going to be a very rare case, indeed, in which someone is running this kind of argument, and yet it isn't apparent on the face of the pleadings or apparent to the claimant by the time it reaches the tribunal. So insofar as you might be worried that some enormous additional burden is going to be imposed on the tribunal, that just seems to us to be unrealistic. But in any event, the need is to, one ought not to be clipping away what would otherwise be the appropriate path to justice for a claimant on the basis of that concern. So I mean, I'm not conscious that Floodgate's arguments have been traditionally successful in front of this court, but I'd be surprised if this variation of it were in this case.
Well, the law is the law,
Yes.
whatever the law may happen to be.
So that takes me, I think, to the last 3 points. The first is, what about the impact on the employer? What is said is, well, how is the decision maker to know of this? So this takes us back to the point I was dealing earlier in my exchange with Lady Arden. That's just the wrong question. The appropriate question is, how is the employer to know? And latent in that is the question, what does the employer know, or what should the employer be taken to know? And that's just the attribution question again. So this objection, what about the poor decision maker, isn't really an answer to our case. It's just asserting again that the decision maker should be the sole focus of interest on the part of the tribunal. The next point, I think the anti-penultimate point taken was, what about the poor employer's reasonable steps defence? And the answer to that is, as I hope I made clear earlier, there already isn't one in relation to section 47B1, which is the section which applies to Mr. Widmer's actions here. So it's impossible to run an argument that it would be remarkable if the defence were not available in circumstances where Parliament has very deliberately not made it available, which is in cases where there is direct attribution to an employer of the actions or motivations of the employee. Then it said, well, what about the poor employer in circumstances where there's a claim alleging that they have provided a reason which is not the true reason? They're going to be found to have given a reason which is not the true reason. To which our answer is, good, they should be found to have given an answer that's not the true reason if they've not given the true reason. So, but latent in it is the key question, which is, what is the true reason? What is the employer's reason for this purpose? So far as longer hearings is concerned, I hope to some extent I've dealt with that already, but let me re-stress the point that if what is being said is the employment tribunal will have to range widely in looking at the motivations of a wider range of people, that also is the inevitable consequence of an Osipov claim under section 47B.
Do we know how many days the hearing took in this case?
I wasn't involved, but Mr. Jackson, I suspect, does know.
It's difficult to see how it could have ranged much further than it did.
Well, that's true. It should be on the first page of the...
Well, they say when it started and ended, but I don't know how many of those days were.
I think your client may remember.
I'm sure she does. 11 days, I'm told.
7 days.
There's no doubt this has been a very hard-fought case and continues to be a hard-fought case. I was struck in the course of Mr. Gordon's submission and in answer to a question from Lady Arden as to what would happen if they were to discover that Mr. Widmer had behaved badly. They said, well, of course, he'd potentially be subject to disciplinary proceedings and sacked. But of course, the tribunal has found that, and as far as I'm aware, Mr. Widmer's still there. So,
yes, I mean, here you had the 47B claim anyway, which had to be gone into, and that's been successful.
it has.
And we're really only concerned with the other bit of it. But
Exactly.
I mean, the scope of the hearing would presumably have been very much the same, however the arguments were being presented.
That would be the case if the prescribed reason was, as it was in your case, the protected disclosure. If the prescribed reason was the other reasons in Schedule A, then there wouldn't be an Osipov type hearing.
I think in all but one, because it's been a while since I've looked at it, but my recollections are effectively matching detriment claims for everything except for asserting a statutory right. So you would be able to bring Osipov claims in many a situation.
Oh, really? Yes. we haven't looked at the relevant provisions, but that's your assessment.
Yes, I mean,
except for asserting a statutory right.
That's certainly my recollection from when I last looked at it. It's a question of looking at section 47. MS 523, I'm told. Right, so Part 5, protection from suffering detriment in employment. You'll see it starts with health and safety cases. Goes on 528, Sunday working.
Ah, yes. Thank you very much. I haven't seen these provisions.
Now,
So it's the whole of Part 5, is it, Mr. Jones?
it is.
Very well.
So my learned friend Mr. Jackson says that there are some detriments hidden away in other detriment rights hidden away in other legislation too, including in the Trade Union and Labour Relations Consolidation Act. So I can't say that they're all there,
No.
but a number of them are contained there, and I suspect the dismissal for trade union membership will be the one in the Trade Union and Labour Relations Consolidation Act. Which brings me, I hope, to my last point in reply, which was this point about, well, what happens in relation to sole traders. Can I invite you, please, to take up the core bundle again, and I hope finally, and to look at MS 103. So here we are in the respondent's case. And just to prove that I've read it, can I ask you to have a look at footnote 23? It says, where a small employer delegates the responsibility of running a disciplinary procedure to an external HR consultant, the test looks at by examining what was in the mind of that consultant. So I don't think it's entirely in English, but one understands the point which is being made. So imagine I am a sole trader. I have to reach a decision as to whether or not one of my employees perhaps has misconducted themselves or whether their performance is not good enough. And I elect not to undertake that process myself, but to do what the respondents accept commonly happens, which is to use an external HR consultant. Unless there was a rule which attributed to me, the employer, the decision that the external HR consultant had reached, I wouldn't have a reason for dismissal. And I would instantly and invariably lose unfair dismissal claims because it's my obligation to prove what my reason for termination is. So that's obviously nonsensical. So the approach which is set out in footnote 23 is incontestably correct, which is that where an individual employer or a sole trader delegates responsibility for the investigation to someone else, and they form the view as to whether or not there should be a dismissal, their reason is the individual employer's reason, because it's literally the only way in which it can be made to work.
So what if the external consultant has been grossly misled?
Yes, well, that was the point that we made yesterday. Let's say the individual employer says, I have within my workforce someone who's about perhaps to shop me to the HMRC because I'm making cash in hand payments. I want to get rid of them from my employment immediately. What I'm going to do is I'm going to contact the external HR consultant, but I'm going to give them such a flurry of artificially created evidence that the outcome is inevitable. Well, in those circumstances, we say the employer is acting as the employer for these purposes. The sole employer's motivations are, entirely logically, their motivations. They are procuring the HR outcome. It should not be possible for an employer in those circumstances to say, although I was thoroughly badly motivated, although I was specifically motivated by the protected disclosures, although I set about to ensure that the termination took place and the HR official gave me the answer I wanted, when this gets to tribunal, I should win an unfair dismissal claim on the basis that, how was the poor HR consultant to know that I was actively misleading them?
Well, we expected you to say that, but a minute ago you said GM packaging was clearly right. Namely, examine what was in the mind of that consultant.
Yes.
You're now adding a rider.
No, I understand. The rider is my whole case. So, sorry, I've been. That's entirely my fault. In an ordinary case.
In an ordinary case, quite.
GM is right.
Yes.
But there will be circumstances in which, and I know it sounds bizarrely artificial, you end up attributing to the employer's own actual
Quite.
motivation.
Thank you.
But it's a question of fact. What were the employer's reasons?
Correct.
And that's the thing that Lord Justice Mummery said in that case we looked at. Obviously, if the facts change, the answer may change.
You're entirely right. So there will be exotic cases, even more exotic cases than this case, but they all still fall within the same principle.
But the external HR facility is something that you introduced. My question was about sole traders and partnerships, some of which are quite large and therefore wouldn't have use an external facility. They would do it in-house. And I just wondered what the rules of attribution were. You brought in LLPs and I thought you were going to respond on all.
No, I wish I was in a position to do so, save that, to repeat what I said yesterday, which is that the rule of attribution, we say, is sufficiently general that if you're looking at someone who could take a decision themselves but is delegating it, then as an ordinary principle, the reason is the delegatee's decision, unless we fall into this kind of circumstance and there's some reason to believe that that decision has actually been determined by someone else who counts as the employer and their motivations. So that whatever the specific rules about delegation, of power might be within different types of organisation, providing you can identify a delegation power.
But there's a major difference because the partnership is not a separate legal entity.
In English law.
LLP.
Pardon me, Scottish law is.
I mean, that creates all sorts of other issues which happily we don't have to decide.
But it may create a difference between different types of employer.
It may do. And it may be that there are specific kinds of employer who, because simply I don't know whether or not there would be a different regime, might raise questions that are, for me personally, presently entirely unforeseeable. And I'd love nothing better than to come back and then argue in front of you those cases, should they arise. But for the moment, I'm just unable to help you. Very grateful.
Can I just, sorry, are you happy, the order on page 141, the EAT order, if we were with you, would you be happy for us simply to affirm that order?
Yes, to affirm the section 103A finding, yes.
Yes, but I mean the 47B doesn't need to be affirmed because it's there anyway. But
My lord, yes.
yeah, thank you.
I was just checking to see whether anybody got any further questions they wanted to put to you, but it appears that that is not the case. So it only remains to say thank you to everyone for the very interesting arguments that they have put before us. And it's not only those who've been on their feet, there are some others who've contributed, I have no doubt. So thank you all too. We will now go away and try and work out what the answer is and let you know in the usual way, in due course. Court will now adjourn.